Hi everybody. Just wanted to do a video on the civil asset forfeiture case that was brought by Fulton County in the state of Georgia. In essentially a parallel action. It is a parallel action to the YSL RICO case that's much more well known. But there are some people and some property and some events that overlap between this case here and the RICO case. And just this week, there was a default judgment entered against Martinez Arnold, aka Duke, who some of you may recall from the RICO. He had pleaded guilty in December of 2022. I think it was December 16th. And so he wasn't as prominent in the trial as some of the other people that you may have watched on YouTube for literally years. So yeah, just to contextualize the default judgment that was entered, I just want to quickly go over the motion for default, and that will give us some insight into the events. I'm not going to read the entire thing because that will just take, as I know from the past videos that I've tried to make, that will just take much too long. But let's get started. The state of Georgia filed this complaint on July 7th, 2022. That would be about 2 months after they filed the initial complaint in the criminal action. Here, they're just saying that Martinez Arnold was charged in the original indictment in May of 2022, and he was re-indicted under a different case number, as was everybody in the case in, let me see, that was August of 22. And the state alleges that the property that they're trying to take, the stuff they want, was used in connection with gang or RICO activity. And here they're just discussing service, how they served Mr. Arnold. And these are various procedural requirements. You have to state that the person upon whom you're trying to enforce or impose a default judgment is not in the military. They're not overseas serving. That's not their justification for why they can't respond. Let me see here. Actually, let's read through this one. On August 31st, 2022, more than 30 days after service of the complaint and summons, the attorney who represented Mr. Arnold in the related criminal case contacted the Fulton County DA's office prosecutors handling the criminal case and stated at that time that she was aware that there might be a forfeiture or seizure action. So it wasn't entirely clear trying to get context. The attorney also acknowledged in her email that Mr. Arnold had been served with something. And it's not clear, you'll see here, what information was provided in response by the DA's office. Same attorney contacted undersigned counsel by email on December 19th, 2022. Again, that was just three days after Mr. Arnold had entered his guilty plea. So she was asking how to get Mr. Arnold's car returned, presumably referring to defendant personal property, in part 2021 white Mercedes-Benz AMG GT that is registered to Mr. Arnold. As you'll see, that's one of the assets that the state wants to seize. Undersigned counsel responded by email to the attorney on December 20th, 2022 and informed the attorney of the instant civil forfeiture action and attached a copy of the complaint as a courtesy. I think that's probably the bare minimum, attaching a copy of the complaint, more so than a courtesy. But one thing to note quickly here is that August 31st, 2022 was actually the deadline, the original deadline to answer the complaint, and characterizing it as more than 30 days after service of the complaint, while technically correct, completely misses the point because the way in which the complaint was served, it extends the period to answer. I'm not going to get too much into the technicalities, but it extends the period that Mr. Arnold had to answer the complaint. So when Mr. Arnold's attorney was communicating or emailing the district attorney's office on August 31st, it, in my opinion, would have been appropriate to tell her, hey, this is the deadline. You want to keep your stuff, you got to do something. And that probably should have been disclosed, in my opinion. But anyway, we'll continue on here. They're saying Mr. Arnold did not answer or move for dismissal or anything like that with respect to the complaint in the time allotted. So on December 16th, 2022, Martinez Arnold pleaded guilty in case 22 SC 183572, that's the RICO, to one count of conspiracy to violate the Georgia RICO and to one count of participation in criminal street gang activity. Saying same crimes which form the basis for forfeiture here. I'm not sure that's entirely true, but that might have to be the topic of another video. Again, here they're discussing defaults in the default statutes and rules. And wherefore, pursuant to the provisions of 916.12, the state requests that this honorable court enter a default judgment as to Martinez Arnold, thereby forfeiting to the state of Georgia all right, title, and interest that Martinez Arnold may have to defendant personal property. The state respectfully requests that this honorable court retain jurisdiction. They're asking the court to maintain jurisdiction so this court can oversee distributing the stuff to Georgia if that is necessary. And respectfully submitted this 23rd day of January, 2023. And I think there is, I guess we can go through this quickly. This is the proof of service. Actually, they call it something different in Georgia. Entry of service in this action. So this is what the process server would submit to the court after serving Mr. Martinez Arnold, or as he's called here, Arnold Martinez. And again, despite the misnomer is probably sufficient, but still you would hope that they would get the name right in the proof of service. And earlier I mentioned the rule, I think it's both a rule and a statute that requires that you show that the defendant not be in the military and that that's not their justification for not answering the complaint. And this is paperwork that the Department of Defense will provide upon request, stating that somebody isn't, that a person with that social and birth name are not in the military. As long as that's not Martinez Arnold's birth year by several years, it's off. So this is insufficient. This certifies that somebody else entirely isn't in the military. Again, Duke isn't in the military, but it's just another bit of sloppiness that should have been avoided. It raises an issue where there really shouldn't have been one. And it's just common and inconsistent with the level of care that has been used in this case and in the RICO case. So this brings us to this week on Monday, St. Patrick's Day. This is the default judgment that was entered by the court, and it's not too long. We'll go through it here. The plaintiff, state of Georgia, having moved for a default judgment against any and all interest Martinez Arnold may have in defendant personal property, and the court having read and considered the motion is hereby ordered that the motion is granted. Specifically, the complaint named Martinez Arnold as an alleged owner interest holder of certain items of personal property was filed on July 7, 2022. The following items were seized from Mr. Arnold or from inside a vehicle registered to him and named in the complaint for forfeiture. So this is the stuff here. And as you see, it's a significant amount of value of property. The car, $4,000. Rolex Datejust watch with blue face. Not that blue face. The diamond Cuban link chain necklace. You can read this. You don't need me to read all of these things to you, but bottom line is this is it's not an insignificant amount of value. It's not, a couple $100 and some leftover food. It's a lot of money, and the stakes are pretty high here. Martinez Arnold was personally served by a deputy. Arnold Martinez was personally served by a deputy with the Fulton County Sheriff's Office on July 19, 2022. Okay, this is interesting. Remember how in the last thing we just looked at in the motion stated that counsel for Mr. Arnold didn't respond until August 31st, which was more than 30 days after service. Contrasted here where it says Mr. Arnold was served on July 19th, 2022. A copy was not filed until August 1st, 2022, which started the 30-day clock for Martinez Arnold. So the judge is more accurate than the state was in this respect by clarifying that, yes, while more than 30 days had passed since July 19th, 2022, as of August 31st, that wasn't relevant because the 30-day deadline, which runs from August 1st, would have been August 31st, which was the date that counsel contacted the DA's office. Let me see. So here the court's saying, irrespective of the deadlines, it's been more than 30 days, it's been more than 45 days, it's been more than 60 days since the deadline, the complaint was filed and served, so the deadline has run. So that issue aside, it's appropriate to enter default. So, I'm just saying, nor has Martinez Arnold filed an answer or any motion or other pleading whatsoever in this forfeiture proceeding as of the date of this order. Martinez Arnold's default acts as an admission of each and every material allegation in the complaint. And that refers to, we'll just get to it here. Additionally, Martinez Arnold is prevented from denying the essential allegations of Fulton County case number 22 SC 183572. Again, that's the RICO, wherein he pleaded guilty to one count of conspiracy to violate the Racketeer Influenced and Corrupt Organizations Act and one count of the Gang Act. Accordingly, it is hereby ordered that any and all right, title, and interest that Martinez Arnold may have in the following property is hereby forfeited to Georgia. It just lists the property again. Saying the state shall immediately take in or retain possession free and clear of all liens and encumbrances of the below listed items of property seized from Arnold and that have not been claimed by any other party. And again, that's quite a bit, but I should clarify, free and clear of all liens and encumbrances. That means that, say, there was a note on the car. I have no idea whether there is or is not, but that means that the car could no longer be repossessed by the company, by the lender, once this order is entered. The debt is still valid as to Mr. Arnold on the car, but the car is free and clear of any right of repossession that the finance company or the dealer would have. These proceeds shall be considered forfeited to the state of Georgia and distributed in accordance with 9/16/19 as follows. The Fulton County DA's office, as the seizing law enforcement agency and prosecuting office, shall sell by any commercially feasible means, which I have to say is a standard that's lower than I've seen in other contexts. Any commercially feasible means seems like essentially any sale would be commercially feasible, just self-evident, really. Usually, I should say usually, but often you'll see some sort of commercially reasonable means of sale, meaning you have to have some kind of bidding or open market competition or in the sale of the asset to make sure that it actually gets value and it's not just handed out for $5. Anyway, shall sell by any commercially feasible means the seized and forfeited Mercedes and the seized and forfeited jewelry proceeds. That doesn't make sense. Never mind. And forfeited jewelry proceeds with the proceeds from the sale minus any costs incurred in the sale to be distributed to the Fulton County District Attorney's Office, in which amount shall be used for official law enforcement and prosecutorial purposes pursuant to 9/16/19. A little bit more. I wonder where that money's going to go. Fulton County DA's office, as the seizing law enforcement agency and prosecuting office, shall retain the $4,126 in U.S. currency. So they don't have to sell the money to get the money. It's cash, so it's just in a separate provision. So, bottom line, the stuff was taken from Mr. Arnold by the state. The state is going to keep it if it's the cash, or sell it and then keep the cash. And it is going to go towards, what was the phrase? Official law enforcement and prosecutorial purposes. But there's an issue. In addition to the ones that I already said, there's another one, or another several. But because I've been going for 15 minutes and I'm trying to keep this to under 20 minutes, and that's not going to happen, I am going to focus on just the one issue, which dates back to September of 2022. And this was back when Judge Glanville was supervising this case, as well as the RICO. This case was transferred to Judge Whitaker at the same time. Actually, I think it was slightly after, but around the same time as the RICO was transferred. So the context doesn't actually relate to Mr. Arnold, so we're not going to get too much into that. We'll just focus on the broader order. And this is discussing discovery, but the court hereby orders a period of discovery to ensue, followed by a stay of the matter as follows. Paragraph on discovery. Given what the court finds will be a complex criminal trial based on the high number of criminal defendants involved, 28, and the extensive indictment, which, let me see, this was after the reindictment. This should be more than 64 charges, but in any case, the extensive indictment, which includes 56 criminal charges, at the conclusion of the 90-day discovery period, the civil forfeiture case will be stayed until the criminal case is resolved as to all criminal defendants. It talks about discovery more, but the critical thing here is all criminal defendants, and he specifically identifies the number of criminal defendants, which is 28. And as of today, unless there's something that's happened since this morning, there are 3 criminal defendants with unresolved matters, and they will be up for trial. I lost track of when that's starting, but I think it was July last I checked. But that'll be, who is that? That's Christian Eppinger, Demetrion Garlington, and who do I forget every time? Demise McMullen. So those 3 defendants still have active pending cases, and as far as I can tell, that means that the stay order should remain in effect per this language here. Stayed until the criminal case is resolved as to all criminal defendants. And that leads me or us to ask, what does that mean for the entry of the default judgment, and for that matter, the motion for entry of default judgment, given that the case is stayed, which just means that the case is frozen. And I found this case. It's funny. As you can see, this is a Fulton County case. Paul Howard Jr., many of you may know this, he was the prior district attorney prior to the current administration, prior to Fonnie Willis. And I enjoyed this one, so I'm going to read through this. Definitely going to take me over 20 minutes, but in any case. This appeal from a judgment in favor of the state in a property forfeiture case presents a procedural quagmire, combining the loss of all or part of the file, no word on whether it was refurbished, an indefinite stay of the proceedings, a motion to suppress filed by appellants Douglas Colden and Valerie Knowles, and a single omnibus hearing combining evidence and argument on the motion to suppress, a motion to dismiss, a motion for summary judgment, and the state's case for forfeiture. That's a lot of stuff. Colden and Knowles appeal, enumerating as error the denial of their motion to suppress and the stay of proceedings. We do not reach the issue of the motion to suppress, and we will come to that footnote, because we conclude that the trial court erroneously conducted the omnibus hearing without lifting the stay of proceedings. We therefore vacate the trial court's judgment and remand for further proceedings. The motion to suppress presents numerous problems of its own. The search warrant and affidavit in support apparently were contained in the lost file because the state did not present them or introduce them into evidence. The testimony of the arresting officer may well have been inadequate to substitute for the missing warrant and affidavit, particularly with regard to facts supporting the reliability of an anonymous informant. As Max Sharp says, the Fulton County Blues. Gotta watch out. And despite appellant's requests, the trial court never entered a ruling on the motion to suppress. We also note with disapproval the state's material misstatements in its original brief to this court regarding the whereabouts of the warrant and affidavit, and its filing of an amended brief without explanation or excuse after appellants challenged the state's version of the facts. But we do not reach any of these issues. So they are displeased, to say the least. In judge speak, they're screaming and throwing stuff. This action commenced with the state's complaint for forfeiture in October 1997. In January 1998, the state moved for a stay of proceedings. Starting to parallel our case. The state moved for a stay of proceedings pending the outcome of the related criminal prosecution. At the time of the hearing on the state's motion to stay, it was discovered that the file was missing. At the conclusion of that hearing, the trial court granted the motion and stayed the civil forfeiture proceedings until the completion of the criminal prosecution. Neither the motion to stay nor the order granting the motion to stay appears in the record. This may well be due to the loss of the file. Moreover, the existence of the stay is apparent from the conduct of the parties and the court in abiding by the court's ruling for over a year. After 16 months, the case inexplicably appeared on a trial calendar. At that time, the file apparently still had not been found. Moreover, according to the statement of appellant's counsel at the omnibus hearing, the related criminal matter was not yet resolved. No charges had been brought against Knowles. The original accusation against Colden had never been pursued, and Colden had never been indicted. The state itself acknowledged at the hearing that this characterization of the status of the criminal matter was accurate, saying that the very reason that the motion for stay was originally granted still remains a valid reason. Seems like that's pretty much should be the beginning and end of it. But nothing in the transcript or the record indicates that the trial court considered the continuing pendency of the criminal matter in the context of the stay or the continuing pendency of the stay itself. The hearing nevertheless proceeded without any order from the trial court lifting the stay of proceedings. After hearing all the testimony, the trial court did not expressly deny the motion to suppress, ruling simply that the state had made out a proper case. In a written order, the trial court denied appellant's motion to dismiss and for summary judgment and entered judgment in favor of the state. But just as notice and an opportunity to be heard are required before a stay is imposed, such notice and opportunity to be heard are likewise required on an interlocutory hearing had to revoke such a stay already granted. So, you got to have a hearing if it's requested by any of the parties, and you need to notify all the interested parties of that hearing. In Howard, the order revoking a stay under the Soldiers and Sailors Civil Relief Act was taken ex parte. I believe that was this statute, the Soldier and Sailors Civil Relief Act. It's either a predecessor or the actual statute that we looked at earlier that had the Department of Defense. It's related to the Department of Defense filing, in which the state confirmed the date of birth and of Martinez Arnold and the fact that he's not currently serving. So that's just a coincidence, but I thought it was interesting. The Supreme Court held that a judgment entered after the improper lifting of the stay was void on its face, and that the prejudiced party was entitled to have it set aside. It's not discretionary. The parties, it's a matter of right. Similarly, a judgment entered in violation of the automatic bankruptcy stay of 11 U.S.C. 362 was void ab initio, was without effect and was in absolute nullity. Title 11, that's the bankruptcy code. It's a lot of fun. We should do that sometime. Here, one thing, perhaps the only thing, that is clear in the chaotic and incomplete record. Chaotic and incomplete it really describes a great deal about the RICO case. Chaotic and incomplete record presented for this court's review is that the stay of proceedings was never lifted, despite the continued and acknowledged lack of resolution of the related criminal prosecution. Moreover, to rule on the issue of a stay of proceedings in the case without any notice to the parties or opportunity to be heard presents significant due process concerns. The judgment taken without an order lifting the stay and without notice and opportunity for the parties to be heard on the issue of the stay was void and without effect. We therefore vacate the trial court's judgment and remand for further proceedings consistent with this opinion. On remand, the trial court must first determine whether the stay remains appropriate, particularly in light of the lapse of time and the apparent non-prosecution of the underlying criminal matter. If the stay is lifted, the remaining issues in this litigation may be considered after adequate notice and the opportunity for all parties to be heard. So there are a few other cases in Fulton County along these lines, but this was the most factually on point. And I think it's fairly clear, very clear, that the order likely hasn't, the stay, has likely not been lifted, and that the order against Mr. Arnold is, the judgment against Mr. Arnold is void, out of space, and you still need to move to set aside the judgment. You can't just ignore it. But as best I can tell, he has quite a strong case, that a very strong case that the judgment should be set aside. And I guess I actually want to show one more thing, just to relate it back to something in this opinion. Let's see this here. I just want to show that the stay has been discussed by the parties and in filings since the stay order was entered, just to show that similar to Colden, where where the court observed that the parties had observed the stay. I just want to show that the parties have done so here. This is written and filed by Brian Steele on behalf of Thug. And it dates back to February 23. And Steele says, he identifies the order. The discovery and stay order was clear and explicit. The order provided that discovery could be conducted for a period of 90 days, after which the case was stayed. And then he states again here, the forfeiture case is presently stayed. And I enjoyed this part, so we can just go through this. It is fundamental that if a trial court has jurisdiction to issue an order, the order must be obeyed until it has been superseded. Talks about discovery. The law cannot function in an environment where one party believes that it is easier to ask for forgiveness after the offending conduct rather than asking for permission before the act. He's right. The Fifth Amendment is used by and protects innocent persons. The state was trying to say that whether and in what circumstances Thug could plead the Fifth, which is bold. This is another action. This one's filed by the jeweler. This motion is filed by the jeweler. It was July of 24, so this is much more recent. And where did I put it? Again, here we go. They are again identifying the discovery and stay order, and I don't believe they discuss it. Now, they mentioned it again down here, but it's clear that the stay was front of mind, and we don't need to get into why, but this portion here, the court will set the matter for a hearing solely on the issue of alleged ownership interest. That's consistent with the stay, so this is also implicitly referencing the stay order. Having hearings solely on the ownership interest wouldn't lead to the distribution of the property. So the property wouldn't be going anywhere, and the judgment wouldn't be, there would be no final judgment entered. There wouldn't be any relief granted. So it's not inconsistent with the stay. And let me see. One last thing I want to show. I'm doing this kind of out of order. Do better in a second video. But just to reiterate the statutory basis for the stay. Let's read through real quick. For good cause shown by the state or the owner or interest holder of the property, the court may stay civil forfeiture proceedings during the pendency of criminal proceedings resulting from a related indictment or accusation, until such time as the criminal proceedings result in a guilty plea, a conviction, or an acquittal after trial, or otherwise concluded before the trial court. So the language actually tracks quite closely with Judge Glanville's stay order. And again, that further suggests and confirms to me that this is exactly what he intended, was to have a stay pending the outcome of all of the relevant, or all criminal proceedings under the YSL RICO case. And to be fair, I think it probably would be appropriate for the court to lift the stay, given that both Mr. Arnold and Mr. Williams's cases have resolved. And as you can see, they are the only parties of interest that are in this action that are involved in the RICO case. So the RICO doesn't really have any open questions for the purposes of this civil action. So it would be appropriate, I think, to lift the stay, but the stay needs to be lifted before the judgment can be entered. And I am confident that Mr. Arnold's attorneys will bring that to somebody's attention, and hopefully we can see the resolution and see whether any of what I just said was correct. Anyway, I can do more stuff on this topic if people are interested. It'll probably be a pause on anything YSL related for the next couple weeks or month, I would guess. I expect there will be some news in that case with the trial coming, and I'm definitely looking forward to covering that some more. There'll probably be some Cameron Reed stuff coming up soon too, and if there are any video suggestions, I'm always open. I don't know if I regret saying that. No bad suggestions, but I am open to any suggestions, so let me know if you have any requests. And yeah, that is everything. Thank you for watching. For 32 minutes, that's more than 20, but that's okay. And I'll see you next time.